Today's case is a ticking time bomb. We're looking at Marcus Aleem, just 23 years old, but his rap sheet tells a different story. He's already on probation for burglary of a habitation, a serious second-degree felony in Texas. Probation is a golden ticket, a chance to avoid prison. But here's the problem. While on probation, Marcus allegedly went on a spree, evading arrest, deadly conduct with a firearm, failure to ID, even assault family violence. And if that wasn't enough, he disappeared for nearly 2 years while the court hunted him down. Now he's back, claiming he's ready to start over. The defense says grief over losing his grandmother pushed him off track, but the state points to a pattern of violence and avoidance. And when the judge finally speaks, the frustration is palpable. Stay tuned, because this hearing has everything: emotional appeals, shocking admissions, and a hammer of a sentence that shows just how thin a judge's patience can wear.
Good morning. You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
I do.
Are there any additions or corrections to the report?
No, nothing's been finished.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete his probation given that opportunity. He understands that his mistakes, that's definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over, get life, live with my family, go back to work, help my mother die, give her bill, and everything else, Your Honor.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
Here's Marcus's explanation. He stopped reporting to probation after his grandmother, his main support system, passed away. It's a sympathetic reason, no doubt. Grief can derail anyone. But here's the harsh truth. Grief doesn't erase probation rules. Courts see this excuse all the time. The law expects you to lean on your probation officer when life gets hard, not run from them. So, the question is, should the court weigh compassion over compliance? If you were the judge, would you give Marcus another chance, or say enough is enough?
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
He pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Can you tell?
I'm sorry, Judge, I didn't look him up after he pled through.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
There was an obstruction in 2023 that was dismissed.
Birthday gentleman. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know.
And here's the bombshell. Marcus wasn't missing for weeks or months. He was gone for nearly 2 years. That's not slipping through the cracks. That's full-on absconding. Think about it. While on probation for a serious felony, with multiple new offenses in play, he disappeared. No check-ins, no accountability, just vanished. This is where probation transforms from second chance to wasted opportunity. What do you think? Does nearly 2 years on the run prove Marcus had no intention of reforming?
I think when he had the prior MTRP, I don't know if it was at the new case or a prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation, and I'm want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, second-degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right?
The judge now spells it out, point by point. Marcus got deferred probation for burglary, a second-degree felony. Then, while on that break, he admits to 2 deadly conduct charges with firearms, an assault family violence, and later evading arrest. This is critical. Even if some of those cases weren't formally convicted, by pleading true in this hearing, Marcus admits them to the court standard. In other words, the violations are locked in. Probation only works if the court believes you'll follow the rules. With a track record like this, Marcus has made that belief nearly impossible.
Because I guess something else must have been pending, maybe misdemeanors or something. You don't go to ISF, so you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
And here it is. The judge's frustration boils over. She tells Marcus, you had your chances. I can't give you a 4th shot. Imagine being 23 years old and hearing that. For separate chances to prove yourself, and every time, another violation, another disappearance, another bullet fired. Literally. This is the harsh reality of probation. It's a deal with the court. Break it enough times, and the deal is gone forever. At this moment, the outcome feels inevitable.
So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff.
And there's the hammer. Marcus Aleem, now convicted of burglary of a habitation, sentenced to 6 years in the Texas Department of Corrections. On top of that, he's officially banned from ever possessing a firearm under Texas law. This case shows us exactly how probation can collapse. Marcus started at 19 with a shot at a clean slate. Instead, he stacked violations, fled supervision, and even admitted to firing guns while on probation. It's a tough question. Was 6 years too harsh, or the only fair outcome given his history? If you found this breakdown as intense as I did, make sure to smash that like button, drop your thoughts in the comments, and subscribe for more dramatic courtroom showdowns. Because trust me, this isn't the last time we'll see probation tested to the breaking point.